and welcome to a special educational Triangle Association of Freelance session about copyright law. Our presenter this evening is a literary attorney and TAF member, Denise Gibbon. Denise, it's all yours.
All right, welcome everybody. We're going to go through some material that I call at the heart of copyright. It's kind of a course that I created, and I give it every once in a while. Drew, have we got the first slide? Drew is going to handle the slides. And okay, if we go ahead to the second one. So the topics we're going to cover with this, from idea to intellectual property. I often find that people don't know or understand the difference between an idea and the expression of an idea. What makes the expression of the idea copyrightable. Where your copyrights come from, creating work that copyright protects, and the elements of that, which we would call authorship, originality, fixation, and perception or reproduction. And then finally, generally works of authorship, what is looked at as being a real author and what is not. Go ahead, Drew. And the next one. So we're going to look at first different kinds of property, just very briefly. As you can see here, we've got real property on the left. We've got on the right personal property. And real property just amounts to usually where we live, a house, an apartment building, open land. That's all real property. Then there is personal property, cars, jewelry, fixtures, furnishings, etc. And then we get to what we call intellectual property. And just as the real property or the personal property can be owned or rented or leased, you can do the same kind of thing with intellectual property. On to the next slide. So intellectual property can also be owned, rented, or leased, or licensed. But what distinguishes intellectual property, that it starts with an idea. We've all seen photos or illustrations of what I've got here, the aha moment, when someone gets a good idea. But an idea alone isn't enough to establish the existence of intellectual property. We need to be able to express or transform our idea so that it results in what we call in publishing, as Lois knows, a work. But what is a work? And you'll see that all the time in your publishing contracts, in your work for hire contracts. They will refer to what is to be done as a work. Next slide. If you take a look at the circle in the upper left corner, suppose I want to write a mystery novel about a woman reporter who works at a newspaper. Once I'm inspired by that idea, I move to that middle circle where I use my creative powers to transform the idea into what we call a creation or expression of the idea. I create characters, dialogue, plot. I might only create one chapter or maybe the whole book. I'm transforming the idea into a story. When I've expressed my idea in a form and to an extent that it can be recognized as usable property with an identifiable creator, then we can move to the third circle. My efforts result in ownership of what the publishing world calls a work. Now that my work exists, I'm entitled to ownership rights in that work. Next, we've got four major forms of intellectual property. We've got patent, trademark, trade secret, and copyright. Once you've created that piece of intellectual property, how do you protect it? You've got to find the right category for it. Patents protect inventions and discoveries. I didn't invent or discover anything, so I need to move on. Trademarks protect designs, symbols, and names in commerce. Although I may find some use for trademark if I decide to do a series of works about this same reporter working on the newspaper, unless I've created something that's more of a commercial product, there's no point in me having a trademark. Trade secrets protect information that has economic value because it is not known. Obviously, I want to make my novel very well known. So trade secret is not of any use to me either. And finally, there's copyright, the subject of this course, which protects the fine arts, publishing, entertainment, and software. And since a novel is a work that easily falls into publishing and entertainment categories, I know that that is the protection I need. Next. Now that we know that an idea must be expressed as a work before copyright can play a role in protecting that work, we're going to look into now what copyright protects. Next, at the heart of all this is 17 USC section 102A, which you don't need to remember at all, but it defines what copyright protects, which is original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Now, this is from our latest major copyright act, which was 1976 and took effect in 1978. The word copyright means exactly what it says, the right to copy. So copyright law protects the creator's exclusive right to copy and distribute his work or allow others to do so. Next. Let's just skip this one. Next. So what I've got here are those three parts of the copyright law that I was talking about before. So if you didn't have a chance to jot something down, I'm trying to make it as easy as possible. It really breaks down into these three stages: an original work of authorship fixed in a tangible medium that is perceived, reproduced, or otherwise communicated. As lofty as this language can sound, it has street level significance in our daily lives, and we want to make it easier to understand. We're going to break it down like this. Copyright protects, first, as we said, an original work of authorship. Remember the word we mentioned a little while ago, work. We defined it before. It's an expressed idea or creation. Next, we're going to deal with original and authorship. Those are the key words in this first section, which help you understand what it takes to create something that is worthy of copyright. We'll often hear, or you will often hear, lawyers and judges reduce the meaning of copyright to just this phrase, an original work of authorship, but each word has special significance. Authorship is the first one we're going to deal with. And although we're used to, although we're used to describing authors as people who write, under copyright law, an author is any creator of any original work that qualifies for copyright. Because what you create cannot exist without you, its author, you cannot become an author until you've created a work. So we can think of authorship as a marriage of the work to its author. And to quote an old song, which most of us probably remember, called Love and Marriage, you can't have one without the other. Next. So we've got works of authorship by various kinds of authors, but they're all referred to actually generally as authors. Sculpture, a sculptor; musical composition, a composer; architectural plans are subject of copyright, architect, etc. Next, our next word, we skipped one, I think, go back, is original. So we've got an original work of authorship. Next. We tend to think of the world's most remarkable creators in any given field as setting the stage for originality, setting the threshold for originality. But when it comes to copyright, it is not very high. While most of what we're addressing comes from the 1976 Copyright Act, originality was a primary concept long before, and judges have repeatedly had to define originality when the term was an issue in cases brought before the courts. We have here a picture of Justice Oliver Wendell Holmes. In 1903, he was one of the first to try to define originality. He said, personality always contains something unique, and that personality expresses singularity, even in handwriting. He was talking about the difference between the words I use to describe a dozen red roses and the words Don might use in describing the same red roses. Though our subjects are identical, our descriptions will not be. The words need only be original to the creator, and they don't have to be brilliant. It's your choice of words and their arrangement or sequence that is key to your originality. If two painters paint a cloudy sky, they too are going to make choices about colors and shapes that will determine originality. So what Justice Holmes called a very modest degree of art is sufficiently unique to meet the threshold for an original work of authorship. Next. And we don't confuse quality or value with originality. These two artistic works are both original. Although Da Vinci's Mona Lisa is priceless, that does not mean that a modern painter's version of Mona Lisa Cowgirl is not sufficiently original. When it comes to originality, a renowned work is not superior to any other original work. Originality does not require your article for Vanity Fair to be novel or one of a kind. In fact, your work may be sufficiently original even though it closely resembles another, as long as the similarity is not the result of copying. So how do we recognize that level of sufficient originality? Next. In order to know how the Supreme Court has answered that question, we need to travel back a little bit to the good old days before cell phones and computers, when most homes had one phone number and every home received a new phone book directory every year. Those directories included what we call the white pages, which listed residents, their home numbers, their addresses, and then there was a separate section called the yellow pages. In the 1990s in Kansas, there was a company, which we'll call Company X, which went around house to house to collect the names, the addresses, and the phone numbers. And then they published a white pages list for that area. There was a competing company called Company Y, and they wanted to use X's list, but X said, no way, which was a mistake, as it turned out, because this case eventually came to the US Supreme Court. And at that point then, the US Supreme Court had to determine, could Company X actually have a copyright in a list like this? Just a straight ahead factual list. While the court recognized that Company X had invested a lot of time and effort in creating their list, the court determined that the standard for deciding whether a work is entitled to copyright protection is its creator's originality rather than the creator's effort. The court held that the white pages of a phone book were no more than a simple list of factual data, and since facts are not considered original, Company X's list was not sufficiently original to qualify for protection. If you look at the box I've marked as exception, they did make an exception. So while a simple list of facts is not sufficiently original, a list of facts where there's something different about the selection and the arrangement could be original. If you go back to the prior slide, we jumped one. There we go. So that box I'm talking about that says exception, there could still be a factual list, but it's got to have something original about it. But basically, factual data does not meet that level of creativity. And I'll give you one example that I think we can all appreciate. If you look at a recipe and you look at the ingredients, you're looking at a factual list. And you can't, if you wrote that recipe book, you have no copyright interest in that list. However, you've got directions below that you write describing what to do with the ingredients, and that you can protect in your recipe book, is the directions of what to do with the ingredients. So bottom line, information or facts alone without some minimal degree of creativity cannot be protected. Next. And this, of course, led to another case that came up shortly thereafter that had to do with the yellow pages. So a New York court applied the same principles we just discussed to a case concerning the yellow pages. In that case, the court held that the yellow page listings in a telephone directory were sufficiently original for copyright purposes. So when we compare the factual lists in the white pages to the entries in the yellow pages, these two cases give us some measure of the difference between what a court would not find sufficiently original and what could meet that threshold. And clearly, the threshold for originality is quite low. Next. So a work of authorship is original when it is original to the author, independently created, in other words, it hasn't been copied, and it possesses a minimal degree of creativity. Next. Our next stage is we've got a work of authorship, so now we've got to fix it in any tangible medium of expression now known or later developed. Next. Most often, most often, fixing something means we need a handyman or a mechanic. It can also mean that one thing is being attached to another, or something is being stable. This is very similar to the legal definition that we're looking for here for fixation, to adjust or make permanent. Under copyright law, fixation allows us to make the expression of an idea stable and permanent. Only then can your original work of authorship be consistently seen, read, heard, touched, or otherwise perceived. If I type my words on the computer in my software and save the words, they are fixed. If I handwrite them, they are also fixed. If I read them aloud and my voice is recorded, the recording is fixing my words and voice. If you paint 3 red roses on canvas or take a photo of them, the roses are fixed on the canvas or in the photo. In all these situations, we have made the expression of our idea stable and permanent. Next. So some mediums of expression that are now known are listed on the left. Pen and paper, CDs or DVDs, marble, vinyl records, film, plastic, paint, etc. These are but a few types of media used to fix the expression of a work, and the work is made up of words, shapes, pictures, or sounds. However, also note on the right that the 1976 copyright provision also wisely protects tangible mediums of expression that are later developed. And that matters because what they allowed themselves was to be able to have the same law extend itself for a long time into the future. And as I was talking to Don about earlier, just before we started, there's a line in most contracts, most publishing contracts, you'll read, or any kind of publishing contract, where the person is licensing or selling rights of some kind that are now known or yet to be devised. And that is the unknown, what is yet to come. And there's lots of things that came up after 1976. Depending on your age, you may not realize that home computers did not enter the market until 1977 and became common only during the 1980s. The first commercial compact disc, which we call a CD, wasn't produced until August 1982. And thereafter, CD players were available. The first commercial laptop was heavy and clunky and did not become more commonly used until 1989. The DVD was invented and developed in 1995 and released in 1996. The concept of an ebook dates back to the 70s, but its commercial development in the publishing industry occurred in the late 1990s. The iPhone wasn't released until 2007 and the iPad in 2010. So even after this section was written into law, several new mediums of expression, which were generally unknown or unavailable in 1976, appeared thereafter. Next. Oh, next one. We had the wrong one. Okay. All right. So our last part of the copyright law is we've got a work of authorship. We've fixed it in a tangible medium of expression. And that tangible medium of expression needs to allow us to perceive, reproduce, or otherwise communicate what we've created directly or with a machine or device. It's really another aspect of fixation. Next. So this is a simple example of how we perceive something directly or indirectly with a machine or device. On the left, we've got who I call Aunt Jane on the grounds of the Philadelphia Museum of Art, and she is looking at what is known as the Rocky statue. If we were standing next to Aunt Jane, she and we would directly perceive this copyrighted work. While we watch, however, Aunt Jane takes a photo of it. On the right, we can see the resulting photo, which Aunt Jane may have taken with her phone or camera, both of which qualify as a device. She may forward the photo to you or me via text, email, or perhaps she even develops and frames it. The point is that on the right, we indirectly perceive in a photo what we all perceive directly on the left. Next. We touched on some of these forms. Just as Aunt Jane directly perceived the Rocky statue, we directly perceive text and visuals in books, magazines, or newspapers. We can perceive them indirectly as ebooks via the internet or on our phones, iPads, or laptops. If you look at the Statue of Liberty on the right, while the Statue of Liberty is a work, it's a work of authorship fixed in copper, so that's its tangible medium of expression. We can perceive it directly if we travel to New York and we go to the island where the statue is located. Or we can go ahead and take a photo. Use a device, take a photo of the statue. When we create that second work, take that photo, we're really creating a second work of authorship. And so the photo of the statue is based on the first work of authorship, which is the statue. The same rule applies to Aunt Jane's photo of the Rocky statue. so that we were looking at a work of authorship, and then she took a photo of that work and she created a second work of authorship. Next. So if we just briefly review a couple of points. First, a work of intellectual property results from intellectual creation of a work to which the creator has ownership rights and for which the creator may apply for protection. If you write an article or paint a picture, both are works resulting from your intellect, and both are the types of works that copyright protects. Because you are the creator, you have automatic ownership rights in the works you create. The key to basic ownership is that the idea has to be expressed. It is not enough just to have an idea. It must be expressed or created in a form that copyright law finds acceptable. Next. So here are the categories that the Copyright Office regards as qualifying for copyright: literary works, musical works, including those with lyrics, dramatic works, and if there's music, the accompanying music, pantomimes, choreography, pictorial, graphic, and sculptural work, motion pictures and other audiovisual works, sound recordings, and architecture. Next. So what the Copyright Office outlaws, so to speak, you cannot copyright facts, ideas, principles, discoveries, procedures, processes, systems, methods of operation, or concepts. Let's suppose your Uncle Joe prepares a written description of the speed of light and records a speech about it. His written description and recorded speech are both protected by copyright. But copyright does not grant Uncle Joe any ownership rights in the speed of light. When it comes to facts, if your sister Susan wanted to paint Mount Kilimanjaro, she would have a copyright in the painting, but no ownership rights in the mountain. No matter how you describe, explain, illustrate, or embody any of the subjects listed here, copyright law does not protect that particular fact or discovery or concept, although it can be the subject of your work of authorship. Next. So, who else creates original works of authorship? This is one of my favorite characters, Naruto. So who can be an author? To answer that question, I'd like to share a story with you about some real life monkey business. A wildlife photographer by the name of David Slater took photos in the jungles of Indonesia. One day he left his camera on the ground, and one of the monkeys, who Slater had dubbed Naruto, picked up the camera and took this selfie. When Slater later published the photo in an ebook, he graciously gave Naruto credit as the photographer. If we consider what you've learned so far, it appears we have the basics for a copyrighted photo. We've got an author, Naruto, an original work created by Naruto, and the original work is fixed in a tangible medium of expression. A photograph, we can perceive it, reproduce it, or communicate it. And we're not alone when we regard Naruto as a possible author. You might have heard of PETA. PETA is, P-E-T-A, is short for People for the Ethical Treatment of Animals. Claiming to represent Naruto, PETA sued the nice man, Mr. Slater, because Naruto had taken the photo. PETA contended that Naruto had created a work of authorship and owned the copyright in the photo. Thus, PETA argued, when Slater sold the photo, Slater had infringed on the monkey's copyright. Sadly, a trial court ruled against PETA, holding that animals do not have standing to sue. Although PETA appealed, the matter was settled outside the appellate court. But for all practical reasons, this photograph is now in the public domain because Naruto is not entitled to authorship. Next. And actually, that is not a total surprise. Even before Naruto's day in court, the Copyright Office had refused to register the copyright in a song written by the Holy Ghost, a photo taken by Still Another Monkey, and a mural painted by an elephant. The Copyright Office has also excluded machines that operate without any creative input from a person. Perhaps in the future, creations by artificial intelligence may yet become protectable if a human author also provides input. And that's the way it is right now, is that basic AI tools are acceptable in creating some works right now. But there has to be a lot of human input in the creation of the work. Next. So just to make sure everybody gets a shot at understanding these, the law is to summarize: copyright protects first an original work of authorship. Second, that original work of authorship has to be fixed in a tangible medium of expression, now known or later developed. And third, the tangible medium of expression must allow us to perceive, reproduce, or communicate the work of authorship directly or with a machine or device. The one other thing I wanted to mention too, in relation to this, because it comes up a lot, I find with my clients, once you create a work of authorship, you have, as I said before, automatically a copyright in what you created. However, in order to sue an infringer, you have to have registered your copyright. So you legally hold a copyright, but until you register the copyright with the Copyright Office, you have no right to sue someone for infringement. And there are benefits to having that right, which include, if you win, collecting possibly attorney's fees from the other side, from the offender, and statutory damages. Okay, that is what I have to present. Has anybody got any questions?
I have a comment.
Joel.
Yeah. I just like to know, okay, full disclosure, I recently hired Denise to go over some contracts. And I want to say that the reason to hire an attorney, turns out in my mind, is obviously y'all are going to ask her questions, but that's secondary. The real reason to hire one is because she or he will ask you questions you haven't thought of.
That's a good way to describe it.
You're going to give me a break on my bill?
No, it's too late.
Too late. You've already got it fixed, right? But no, that really is. You don't know what's going to bite you in the ass.
Yeah, you really
And
don't.
you're better off to at least, in good faith, she or any other attorney is not, completely 100% going to remember everything or whatever, but for damn sure they know more than you do.
And one of the things I run across all the time with people, it's very funny. I'm working on something for them and I will ask them, okay, do you have any other emails from the publisher? Do you have any other documents from the publisher, anything that would relate to what they told you they were going to do for you? Oh, no, I don't have anything. And then maybe a week later, I ask them again and they go, oh, I did have such and such. And it's amazing. Or, gee, it just occurred to me, I did have an extra email. It's people just don't realize until you ask them, and you have to press them sometimes. Your attorney If they're doing something for you, they need all the information you've got. They might not use it all, but until they have it all, they don't really know how to evaluate your situation.
Denise, could you talk a little bit more about registering our copyright? Towards the end, you mentioned that it needs to be registered if we're going to go after someone who may have misappropriated our work. How do we do that? Or I write nonfiction magazine articles, so I'm assuming that that's all on the magazine's end, you know what I mean? But if I was writing a novel or a short story, what options do I have?
Well, it actually also applies to you, because the magazine has a copyright of the magazine, the whole magazine. In other words, everything that's in it as it is. You might consider having your separate copywriting, registering your copyright in your article, to protect the article if the article is removed from the magazine. And as far as registration, the Copyright Office has got a great website. It's tremendous, or platform. And it's very easy now to do it online. Although if you are publishing your work both as an electronic publication as well as print, you will need to send in your print copy to them. But if you're doing only an e-publication, then you would send that in. But it's very straightforward. But I certainly encourage everybody, they've got instructions, detailed instructions. You sign up for an account, so to speak, and it's best to look at their videos. They've got a lot of instructions about how to use the system once you get inside it, how to answer the questions. And it's not very expensive. It's depending on what you're registering. I mean, I think the average now is like $45 to $60. So it's not overly expensive at all.
That adds up.
Well, it depends. You know, that's the other thing. You don't have to register everything. I mean, there's some things we do that just, it's not worth it. I mean, if you've got a blog and you do an entry here and there, I mean, you put a copyright notice on the blog, but if your short entries are just short entries, it's not necessarily important. But if you're doing a book, yes, you would want to register the copyright, or you're doing a long article. I would think so.
The belief
Denise?
used to be that if you just mailed yourself a draft of your work, you know, and you're familiar with that, Denise, I'm sure.
Oh, yeah, I did it.
So
I
explain
used
why
to-
that is. Explain why that is nonsense.
It's not acceptable. They just won't accept it. It's not, people used to think that that was proof of the fact that they had done something at a certain time, but it's just never been legal. They won't accept it as a legal record.
Gotcha.
It never made sense to me why people would think that would work.
Well, it did make a little sense to me at the time, because you know, if you had this sealed envelope that was postmarked on a certain date, then it seemed to me that it would show that you had done something by that date, on that date.
Everybody could
I've
have put
done
it in
that
there.
when I've
You don't know
sent-
when they put it in there.
Send a
Pardon?
manuscript to an agent. Back
Well, that
before
gets to be a whole other thing.
internet.
And often people, you know, shouldn't just send those in. Most agents are very honest. I mean, they're not going to be stealing people's property. I wouldn't worry about that. You know, if you've personally had that experience, it's a little unusual, but there's a lot of stories out there. You see a lot of cases in court where people think they wrote a story about Joel had this, I guess, about a bear.
Yeah.
Wrote a children's story about a bear. and then finds out that somebody else has written a story about a bear, and they're claiming that he is infringing on their story. Well, there really wasn't much, if any, of a relationship. I mean, two stories about two bears. I mean, it's not enough. It's not substantially similar.
Now that was copy, actually, she had a trademark. which
Oh,
was-
that's right. She was dealing with a trademark,
yeah.
but still, she had a copyright in that too.
Mhm.
Paul, did you have a
the
question?
trademark give her extra protection, or what is that doing?
Well, it's different. It's different. She didn't, the trademark, I'm not sure that would have stood
Uh-huh.
if challenged. That's the other thing. A lot of this is you go ahead and you register your copyright. Okay, fine. You've got registration in your copyright. If someone else comes along and says, oh, that person shouldn't have that copyright, they shouldn't be entitled to ownership of that particular thing because they've infringed on mine. Well, it could be if you lose the case, then you lose your registration and your copyright of that particular item, that particular work. It's kind of like there's a frame of reference, so to speak, and you're okay until somebody challenges it.
Mhm.
When you
And there's
said,
a lot of that with trademark.
So quick question is, so a paperback and an ebook of the same, novel, those are two separate copyrights?
No, you're registering your copyright in your
They're two different works.
in your novel, okay? And what they want, if you're going to publish it as both in two formats, if you're going to publish it as an ebook and a print book, then the Copyright Office, at least to date, wants a copy of the printed version, because they collect, these are samples, so to speak, they collect the proof of what you're registering. All right, and that's their practice. All right, and so they right now they are still collecting print copies if you're going to print and do an ebook, or if you're just going to print.
Hmm.
They want the print copy.
Because layout for an ebook is different than layout for a print book.
Layout is different, yeah, but it's not that different. In other words, the contents of your work.
Yeah.
It's the contents of your work.
That collection of words.
Mhm.
Yes, the collection arrangement of words. I mean, it's basically, even though the format as far as how it appears at the beginning, how it appears at the end might be different, the cover, but it's the same work. And so if you're
Oh, I'm
only
sorry.
going to publish it as an ebook, then you would be sending in one of the files that they find acceptable. They have a list of the types of files that they will accept for electronic books.
The other thing that I was confused about is how they define series versus an individual item. So if I'm writing a series of books, but I only have one right now, I'm not sure how that applies. Do I claim it's a series for the first book, or?
I don't think so.
Would he have to do each book as it is produced would be copyrighted individually?
Yeah, well, again, use of language, okay. It's not a matter of copywriting it. It's a matter of registering the copyright he has in what he created. Remember, so whatever you create, you write that article done, then
Right.
you immediately have a copyright in the article. So it's a matter of whether you're going to register your copyright ownership in the article.
Maybe.
So if Paul is producing a trilogy of 3 individual books, would he need to register the copyright for each of those 3 books?
Yeah,
Okay,
yeah,
One is
to my
different.
knowledge,
Yeah.
okay.
It's
Yeah.
cited
because it's a
But-
separate
but-
work.
Wait,
content.
to my knowledge, but you need to look more closely at the Copyright Office. They've got, I mean, it's a Bible. I mean, it's a lot of material.
When you said long article, is their definition for that? Like how many words
No.
are considered?
No,
Okay.
no. I'm just, I'm just talking about the difference between, you send a letter to the editor of a magazine and they publish 2 paragraphs.
Yeah, you wouldn't.
I mean,
What about the inheritance of the copyright?
well,
As you know, because my father being an author, and so some of the contracts you were looking over were for republishing in new media of some of his old novels from the 60s and 70s.
right, but you have the rights.
I still own the copyright the same way.
You have
No,
the rights through inheritance. As our conversations, I think, reflected. So you've got your copyright for the life of the author plus 70 years, which is an awfully long time. And we only got there because Disney wanted to protect Mickey Mouse. So they kept extending it. And Irving Berlin wanted to keep protecting its works. So
You're
it got
familiar
very
with
long.
his suit against Mad Magazine, right, Denise, in the
The what?
60s? When Irving Berlin and a handful of other composers sued Mad Magazine over a thing they did called the Mad Songbook, which was parody songs that were sung to the tune of. And there was no actual musical notes and there were no original lyrics, but Irving Berlin sued and others with him. And it went up the court a few levels before it was decided that it was parody, and parody is protected speech.
Parody is protected.
Yeah, that was a fairly significant and important lawsuit, actually.
Oh, I am sure. I am sure.
Yeah, it was pretty big. And thank God Mad Magazine won, because it would have cost them a fortune had they lost that case.
Well, I bet it cost them a fortune anyway.
Yeah, just to do it. But Bill Gaines was a multimillionaire anyway, so he could afford it. But Lauren has a question about second authorship and infringement. Lauren, can you unmute and ask her directly? I just want to make sure I don't quite understand what your question is.
Thanks, Don. I may not know quite how to phrase it. So let me, Denise, give you the situation, but I think it relates to what you talked about, the first authorship and the second authorship. Okay, so there are figurines that I have, and I arrange them in different scenarios. Now, let's assume that these figurines, since they're little teeny statues, someone has a copyright and authorship in these little statues. So I arrange these little statues, they're little figures. And then I photograph it and I write little stories about them. So from what you were saying, I would be the second authorship. But my question is, am I infringing on the first authorship, the figurines? And let's assume that all these figurines are registered with the Copyright Office. I mean, I don't know that, but let's just assume it, because that would be, I don't want to be a party to a lawsuit. Does that make sense?
In a way. Now, when I was talking about the first authorship, the second, I was just kind of referring to the fact that, if I stand there and look at the Statue of Liberty and I take a photo of the Statue of Liberty, well, obviously the Statue of Liberty has been created by somebody else. Okay.
Right.
Then I have created a photo, another work based on the Statue of Liberty. So there's no the only relationship is the subject matter. I have my own work of authorship that I've created. So you have created your work of authorship as far as you've taken these photos of these figurines, right?
Correct.
Okay. Assuming that someone holds a copyright and that copyright has not expired, because they might be in the public domain. All right.
Okay. These are not, I'm pretty sure, because it's little fairy garden figures. So yeah.
Oh, well, all right. And have you looked at them for markings of any kind?
No.
Okay.
I'm not sure there are any on them. But yeah, I don't know if you're familiar with any of this stuff. Yeah, it's little teeny fairies and then they have
Okay,
little
are they
houses.
collector's items of some kind? I mean,
Not necessarily. I mean, they're just sold, different companies sell them and you buy them and you put them out in your garden,
okay,
and
all
you
right.
create little, little places, or you can put them in terrariums.
I actually can address that because for 20 years I worked in that market. And that brings up the interesting question of work for hire versus copyright.
Well, that's
So-
a whole other,
Yeah, this
Yeah.
is not a work
So
for hire.
what happens here is I would be contacted by a company, let's call it Ralph Parker, one of the miniature companies, and they would pay me to do the following figurines, and I would create those and send them to them. They would send me money, but it was not a royalty relationship. It was work for hire. That's why
right.
if
Yeah,
you work
that's
for
not my
Hallmark,
question though.
yeah,
That-
because it's
That's
the
off
company
track.
that would hold it.
That's
That
how,
would-
that's how they got created. What you're
Right.
talking about is how they originally got created, but someone hired you, paid you, and they owned the copyright if they're
Exactly.
in what was created. Now
Right.
she's taken those works and she has done a photo of the work.
And
So-
I'm writing a story.
And you're writing a story. All right, but that's kind of, that's not related. The physical figurines, the question is whether they are subject to copyright protection. That's the question. And I'm not sure what to tell you. If there's no markings, there's nothing on them, you know where you bought them. Do you?
Well, yeah, I do.
Okay, then I would go back there and I'd kind of double check on the source. And if you can find the manufacturer.
Oh,
Because you might need permission from them to go ahead and use the figurines in the photo.
okay. Well, that's what I was thinking, which is, so I'm not going to do that. So I'm not going to, so I won't do my authorship thing, right? Because that's too much work. I'm
And-
not gonna do that.
And that's exactly where, whether you're writing or you're doing photographs, where people make decisions about what to include or not include in a work. They start
Yes.
out with a concept, an idea. Oh, I'm going to use all these paintings done by
Right.
other people. And then they find out, oh my gosh, to start every chapter with one of these paintings, I'd have to locate every one of these painters and get permission. And then, nope, I'm not going to do that.
Yeah.
Get
In a
the paint-
practical sense, the
Yeah,
manufacturers would love that as publicity, unless you're doing obscene stories.
right.
Well, I
Well,
believe
no.
Stephen King used song lyrics in one of his novels. He had song lyrics that opened every chapter, if I recall correctly. But I also
Lots of
believe
people
he
do
got
use-
permission from the publishers, the
You get
ownership
permission.
of the music, to use a portion of those lyrics.
Right.
You know,
right.
he did the right thing. He didn't
Yes.
just say, I'm going to use these, but he said, can I use this to open a chapter in my book? And they said, sure. You
It's
know,
always best to try. If it's something you really want to use, you need to try to find the source. And if you cannot, I would keep a record of every place you looked. And if you absolutely cannot, and you get to the end of the road, well, you might go ahead and use it. But then you can at least, if someone comes out of the woodwork and says, hey, that belongs to me, you can show, well, you never marked it. And here I tried to find you. And there are services that now, you pay them and they go out and they do that work. They
Mhm.
locate original authors.
Rebecca, did you have a question? And Hannah, I'll get to you next.
Yeah, so I have an interest in self-publishing, and I've heard about probably most publishing retail sites like Amazon and whatever, they act more as a store, right? You upload your work and they sell it for you, and then they send you royalties. But I have heard of there are some who are smaller or whatever who want to try and basically stake a claim in the copyright just by you uploading to them for them to sell, right? are there any sort of clauses in a terms of service that we need to be aware about for that sort
Well,
of thing?
yeah, just that. Be
Anything
aware
that would
of
claim,
whether, well, it's one thing for you to go ahead and license your work to
Right.
somebody to sell or display.
Mhm.
You're going to license it. You still hold the copyright. Licensing is like renting. You know, usually for a specific period of time, you're going to license your story, for example, to them to publish with other stories, perhaps. And you're going to receive something in return, but you don't want to sign anything where you're actually giving up your copyright.
so any sort of language that would like go in that direction is.
Yeah, I
not
would
good.
not do it. I would not.
Okay.
Egregious. Yeah.
Yeah, right.
That makes sense.
I was telling Denise before the session started about a contract I received a long time ago that basically gave the publisher the right to resell my work to a third party without compensating me. And, you know, that was one of the most egregious contracts I'd ever received as a writer. And I ended up actually not working for that company, which is probably a good thing. But it goes to show you, and as I have always said in all of my classes, read your darn contract. Don't just sign it and send it off. Read it. Find out what you're giving away. Find out what you're getting, and if something is egregious, you can try and work with the editor to rework it to your benefit. It always helps to ask. Nothing bad ever comes from, standing up for yourself in that respect, I think.
Yeah, no, I think it's important. But the thing is, sometimes people just don't understand the language in the contract.
Yeah,
And that
it can be thick legalese that's like you need a knife to cut it. Yeah. So,
and
as Joel
there's
said,
one,
that's what attorneys are good for.
I saw one from Hachette recently that was really it was really interesting because they did a whole presentation of what it was going to be about when they published the book, the first half, like 8 pages, and then another 8 pages defining all the terminology they'd used in the first half. And those definitions in the second half had tremendous impact on what you had thought you were reading originally in the first half.
Mhm.
So you have to be really, really careful about this, and don't criticize yourself if you don't understand it. You don't understand it, go get some help. Don't just assume, well, I guess it's okay. Because Don's right. I mean, it can come back to bite you. I mean, there was one person, I worked for the Authors Guild for many years ago, and there was one woman who called one day, and she was saying that something had happened with her publishing contract, and she thought they shouldn't be doing such and such. And I said, well, did you have a lawyer look at the contract before you signed it? And she said, well, why would I do that? They had a lawyer.
Oh,
Yeah,
God.
but the lawyer works
You
for the
especially need one.
Hannah, did you have a question?
I did. I written a series of poems, and while I'm writing these, lots of melodies came into my head. And one of them, Imagine No More Cakes or Frosting, Imagine was going through my head. John Lennon's song.
Mhm.
So will that be a parody, or is that not a parody? And like, what do I do?
Well,
I mean,
original
using the-
lyrics sung to the tune of?
It can be, yeah, because as I wrote it, that was going through my head, and all the words match that melody.
Well, I wouldn't even go there.
Yeah,
I would
Don't worry
create
about it.
another melody.
Okay.
Just to be on the
Totally
safe
create
side.
another
'Cause
melody.
I don't know that people would pick it up just reading the poem. Would I be
Oh,
safe?
well,
that
all
way?
right. I thought you were talking about writing the music for it.
No, oh God, no.
Oh, you're just
But
talking about the
the
words.
poem could be read to the tune of Imagine.
Yeah.
Kind of that cadence, right? Right?
Yes, it's that cadence.
Yeah.
Yeah.
Don't even say it.
Yeah.
That's what I was planning to
Yeah.
do. Wanted to make sure I'm going to
Let
be
the
safe.
reader figure it out for themselves.
And there's
Yeah,
a
I
blues
don't-
one too, but I figured that's newly created, and it fits the schema for blues. And my friend who's a musician, she said, you're safe with that because it's original thing.
Yeah.
Wait a minute. I missed something. So in other words, she wrote something that you're
No,
using?
I wrote it. I wrote everything.
Okay,
It's a blues poem.
okay,
Just that one you don't have to worry about because you're following something that's already set for the rules of blues.
oh, well, you're just,
Music?
you're writing words.
Yeah, so she
This is
said you don't have to
words,
worry
right?
about that one. Yeah.
Yeah,
Now, I had one other question. For my book, Another Girl in Pants in Our War with Paraguay, it's all taken from newspapers from the 1840s, 50s, and 60s. Now, the New York Times has an entire, because I've subscribed to the Times, I have access to their section they call the Time Machine, which is a photograph of all their stuff back to 1851. Now, they mark that as copyright. I mean, you can pull an article up from, say, October of 1858, and you'll see at the very bottom, copyrighted by the New York Times. Now, I don't understand.
well, wait. You see at the bottom of the article itself that they've replicated, or you see that as
Oh,
a
no. You
marker?
say you see
overlay.
that in the PDF form, not in the original.
Okay,
It just says, any article that you look up there, it'll say, copyright so and so. And I'm thinking, I don't think so. That's older than Mickey
Has
Mouse, so it all
copyright,
does
doesn't
not.
it?
Well, what gets interesting is if they've collected those things and they're putting them out now and in this new form as PDF, and they used to be just on paper. So they are going to claim, and this is a good argument in this, that this is a new work, that
Mhm.
they've created a new work with these old works.
But I've transcribed it, not used their picture.
I'm sorry, you've transcribed.
I've transcribed the article rather than taking a screenshot of the
Oh,
PDF or whatever. Because, I want to quote, okay, this is what Lincoln was saying, blah, blah, blah.
right.
And
you could have possibly found that someplace else. I mean,
yeah, well, because most of it's,
City of New York, I mean, their library or something.
yeah, well, not only
Possibly.
that, but however many papers, that are being published then too. But that just struck me as odd that they would claim copyright back to something like the 1800s.
That's interesting. Well, I'm sure.
I'll send you.
That's what I think their argument would be, is they created a new work.
They created a new list in a sense, but I'm not using the whole list. I don't interact with it as if it's an entire list. I simply go, oh.
Well, no, they're creating a new work with all these old articles. In other words, these old articles are available to you if you want to use our PDF. You can look at them, but you can't necessarily quote them without our permission.
Can't quote them without their permission.
I mean, that's what it suggests. That's what it suggests. And that's why I'd call them and ask them.
Okay.
Rebecca, do you have another question?
Oh, okay, there we go. I'm unmuted. So for those of us again who are self-publishing, if we have a co-writer, how would we go about like drawing up a contract between ourselves, just kind of to
A joint author agreement.
Yeah, exactly. How would we go about doing that?
Well, first sit down and decide how the two of you want to handle the writing of what you're going to do. I'm not sure what you're going to do, but for example, if one person was you were going to do a children's book and one person was going to do the illustrations and the other was going to do all the text. All right, something like that. You want to divvy up what each of you is doing. I've done one where one person was going to put up the money and do all the editing, and the other person was going to do the basic research for the book. So, I mean, it depends, but it's good that you explain to each other, decide how you're going to spend your time. And then there are other provisions that I would put in there that have to do with the copyright, that you're going to share the copyright. If anything happens to either one of you in the process of creating the work, or after creation of the work. I mean, there's provisions that have to do with that. Because, you know, if something happened to you, heaven forbid, but it did, what happens to the work if it's not finished or if it is finished, you know? So there's things to expenses.
Mhm.
Are you going to open a bank account? Are you going to open maybe an LLC so that you're going to have one place with your bank account, an LLC and your bank account, and there's going to be one place where all the expenses, you're going to both contribute a certain amount of money perhaps, and then all the expenses come out of that account. It's a way of monitoring everything. And then if you get royalties, that they go into that account.
Okay.
And it makes it much easier to do taxes when it comes to the taxes.
I gotcha. Well, so what would happen if if you have had co-written, like two authors, not illustrating and authors, but
Yeah,
two
there's
authors.
two authors.
So what happen if one of them, something happened to one of them, and like does that their share of the copyright go to their spouse? Does it go back to
It
what
could go,
that's not
yeah,
defined?
it depends on who's in their life, you know. That's the other aspect, is people don't realize if they've got a will or trust or whatever, they want to add provisions that has to do with their intellectual property.
Heirs and assigns.
So if I would actually be curious about that. This one right here would potentially benefit from my my copyrights after I pass. So I am curious to know how you would go about transitioning that copyright to heirs, when that happens.
You put those provisions in your will.
Oh, I see. So
Okay.
like you would say, he gets my vase, he gets my house, he gets my books, like my
He
intellectual
gets my
copyright.
intellectual property. These are the passwords to my various
see.
accounts.
Can't
He
you
gets
put that
those.
in the agreement itself, that it would
The
pass
joint
to the heirs?
author
And
agreement, you
Yeah,
might
yeah, you-
indicate in the joint author agreement that each of you or one of you has made provisions for what happens
Mhm.
to what you own, if anything happens to you. But this often has to do with in the course of creating something, who's going to finish the book.
Mm.
All right.
Yes.
And things like that.
Okay, interesting.
Practical aspects that people
Okay.
forget about. Yeah, just one thing is, don't start working on anything until you have an agreement. And
Yeah.
I'm sure you have already, but I can't tell you the number of people who have come to me and, oh, well, we've just finished a book and we thought we ought to have an agreement.
Well, as a future idea that might happen, yeah. But yeah, that is something that I had thought about, and I didn't really, wasn't totally sure how you would go about kind of.
Yeah, well, because the
doing
trouble
that.
is too, sometimes people start having arguments in the midst of creating the project.
Right.
Difference of opinion about something, and things aren't going well, and then you want an agreement. How are you going to get anybody to agree on anything?
That's a real
Yeah.
good point. Yeah.
You have, in your original joint author agreement, you have a way to resolve, you preferably should have a way to resolve issues, some kind of
Oh.
mediator, perhaps.
Mm-hmm.
Gotta have a contract though. My father co-wrote a musical, and they did it off Broadway first, and then they were looking for agents for film. And my father, I could not believe, did not have a contract with this guy. And while he was out of the country on his sabbatical, the other one sold off all of the rights.
Now, wait a minute, you mean he co-wrote, wasn't it 1776 or something?
No, no, it was something you probably never heard of. I
Okay.
only just got here myself, was the name
Okay.
of the
So the
musical.
two of them did it
Yeah.
together.
It was about somebody who gets a chance to see what his life is going to be like, so he can decide if he wants to be born or not.
Okay.
So, and it was a huge hit. It was word of mouth only, and they had standing room every single night.
Yeah.
And
Yeah,
they would get
that's
about
the thing
20
too. That's
people.
another thing you can put in the agreement, is
Yeah.
that neither one of you will grant any rights to anybody, to any third parties, without the permission of the other.
Yeah.
Because otherwise you do, as joint authors, without an agreement. I mean, This has happened a lot with songwriters, you know, two or
Yes.
three songwriters wrote
Fogerty.
together.
Yeah.
And one of them wanted to do something with the piece that the other two didn't, or vice versa.
Mhm.
They've ended up in court over it.
Yeah, John
Hmm.
Fogerty got really screwed. One of his brother, I believe it was, or somebody else, sold rights to certain songs for like $50,000. And they were worth millions. And of
Yeah.
course, we all know that Fogerty just very recently got the rights back to the songs he wrote for Creedence Clearwater Revival
you just
after
get those?
decades. Yeah, it was a heck of
Yeah.
a fight.
Well, it's very
That's a
painful,
tragic
too.
story.
Even though you're required by law, he still had to split the $50,000 with the other writers, but it's only $50,000 instead of 3 million, you know.
Exactly. So, yeah. Anyone else have any questions for Denise? No? Denise, this was awesome. Thank you so much for this. This is a session that we really, really needed. I'd like to talk more about business stuff moving forward. You know, do some certain sessions on this. So maybe later on in a few months, we could do another one on something. But this
Okay.
is really informative. I really do appreciate it. I can't thank you enough. This was terrific.
Oh, great.
Yeah,
Okay. You're
very much
welcome.
Thank you.
So thank you so much.
You're welcome.
Guys, thank everybody. I'm going to turn off the recorder.
Yeah, thank you, everybody, for coming.
Yeah.
Thank you, Denise. It was
Thank you.
wonderful.
It's really
Okay,
great.
good.
Very helpful.
Bye-bye.